Just saying you are hurt and you can't work isn't enough to get Social Security disability. You are going to need medical proof. And today I'm going to talk about 5 things that I see Social Security judges look for when cases to go to hearing, and specifically, what are they looking for in the medical Kaplan Morrell with the law firm Kaplan Morrell. We've been helping injured and disabled workers and their families get the benefits they deserve since 1997. I hope this video helps you understand the Social Security disability process, and we would love to be able to help you. If you're trying to get Social Security disability and you're running into a brick wall, give us a call. In a Social Security disability hearing, there's going to be an administrative law judge, and they're going to be looking to 3 broad areas to determine whether or not you meet their definition of disability: your work and your education experience, your testimony, and your medical evidence. And today I'm going to talk about the medical evidence and what I see judges look for when they ask my clients questions to dig deeper into what's going on medically. So, number 1. Judges are going to look for, are you compliant with the treatment? Social Security judges figure that if a medical condition is serious enough to keep you from working, then you should be working hard to try to get better. And this means you're going to medical care. It means you're following the doctor's recommendations. Now, a lot of times my clients will say, well, I haven't been getting medical care because I've lost my health insurance. Well, okay, but then are you trying to get care with charity services or indigent medical services? You got to be prepared to explain why you aren't treating or why you aren't following the doctor's recommendations. There can be a lot of good reasons, a lot of justifiable reasons, but we're going to need to explain that to the judge. 2, are you taking your medications? The judge is going to look at whether or not medications, prescription medications primarily, have been recommended. And if not, I see them wonder, well, why? If this injury, if this condition is so disabling, so awful that it's knocked them out of the job market, why are they not getting medications? There may be some great reasons why. And if they are recommending medications, are you taking them? Because if you're not, we're back to, well, maybe you're not compliant with the medical care. Did your medical visits increase when you became disabled? Now, a lot of times people, because of some medical condition, they don't lose their job right away. They don't become disabled as Social Security defines it right away. It happens, and then things start to get worse and worse and worse. As you can imagine, if something happens, you go to the doctor, you're trying to figure it out, and over time we see a lot more medical appointments because, after all, my client's trying to figure out what's going on. Can this be solved? Can this be cured? Can I get better? I'm about to lose my job. They're going to expect a lot of visits to the doctor, especially as you start to lose your job, or right up to you losing your job because of the medical condition. This goes back to judges thinking that if a medical condition is serious enough to make you unemployed, you would fight hard to get better. So what we should see, or what the judge is hoping to see, is a lot of medical care when you stopped working. And this makes sense because especially if it's an accident or a sudden thing, where there's going to be no treatment, and then all of a sudden the accident happens, a lot of medical care. But if your condition is a chronic injury or chronic disease and got worse, we should see more visits, more medications as your disability became worse enough to start missing work and losing work. Number 4, what are your restrictions? Now, anyone dealing with disability knows it's kind of weird when your capabilities and your abilities get boiled down to a list of can and can'ts. And while your own assessment is helpful, most Social Security judges want to know what a medical doctor's opinion about what you can and can't do. And here, what we're needing is what I call numbers, not vague or conclusory declarations. Like, I can't lift much is kind of useless. I don't know what that means. A 2-year-old may say they can't lift much versus a 25-year-old. That's going to be a very different number. So we need to put numbers to the restrictions, like I can't lift more than 10 pounds. I can't stand for more than 10 minutes. I have to lie down every 45 to 65 minutes, and I need to lie down for 10 minutes. Again, you're wanting to give the judge primarily numbers, restrictions that are measurable and quantifiable, and you know when it is or isn't within those restrictions. So again, numbers. What are the restrictions? The Social Security judge is going to be looking for numbers, or anything that is specifically limiting what you can and can't do. 5, are the restrictions based upon a long period of treatment? Now, ideally, the restrictions that you're going to take to the Social Security judge to say, hey, I'm disabled, here's the doctor's opinion of what I can and can't do. Hopefully, those restrictions are going to be given by doctors who have treated you over a long period of time, not just a doctor who saw you once. So if you've got a treating doctor who has treated you while you suffered with this medical condition, that's the doctor I want most to give an opinion about what you can do on a day-to-day basis. Now, what if you don't have such a doctor? What if that doctor's gone, or you just haven't been able to treat with a doctor over a long period of time? Or what if that doctor is even refusing to give you restrictions? There are options, but it's going to make it harder, more challenging, but it's another reason why you need to have a lawyer who will be able to help you overcome that problem. Now listen, I've explained to you what administrative law judges look to in the medical records that aren't entirely clear to most folks applying for Social Security disability. And that's one of the reasons why it's really important for you to get an experienced attorney to help you get all of the information and evidence you need and get it in a manner and presentation that the judges need and are looking for. That's where an attorney can help you. So if you or a member of your family need help with a Social Security disability claim, please call us, text us, go to our website. Our initial consultations are free and confidential. And remember, we only charge what's called a contingent fee, which means we don't get paid unless we're successful in getting you Social Security disability benefits. And with that, thank you for spending part of your day with me.